All right. Since it's just a bit after 1:30 and we have a busy agenda, I'm going to get us started. Thank you, everybody, for joining us. My name is Eric Hauge. I'm the Executive Director of Homeline, and you're joining us today on Wednesday, September 2nd, 2020 at 1:30 in the afternoon for our weekly COVID-19 related tenant landlord housing related webinar. We've been doing these since about mid-April, and you're joining us today for about a 90-minute presentation and opportunity for Q&A with a number of guest speakers that we'll have today. And before we get to introduce everybody, just want to run through a couple quick things. Just a reminder about what Homeline is. We're a statewide nonprofit organization. We provide free and confidential legal advice over the phone or via email to renters. We've advised about over 250,000 renters since we opened, and we advise folks in 4 languages: English, Spanish, Somali, and Hmong. Our hotline number is there on the slide. And then just a reminder about these seminars. Like I said, we've been hosting weekly webinars on pandemic-related issues since about mid-April, and we have a number of guest speakers today, but want to just give you a heads up for next week. We'll have another 90-minute session, and Dan Hilton, the research manager at Housing Link, will be joining us to discuss sort of what they're seeing about the rental market, renters' ability to pay amid the landscape of economic uncertainty and patchwork of eviction protections, as well as the impact on rents, vacancies, and sort of other Twin Cities rental market trends. So that's next week, and we'll send out a link in the chat for the registration and information about that. And then, as always, we have recordings of the past seminars on our website, as well as a number of pandemic housing, tenant landlord related legal FAQs and other information. So with that, I'm gonna pass it over first to, we have a couple of guest speakers today. As the information the registration had, Joel Selzer and Alyssa Wetzel-Moore are joining us from Minnesota Housing to discuss and go through a number of slides and maybe answer a couple questions up front about the Minnesota Housing statewide housing assistance, COVID-19 housing assistance program. And then after that, we have Assistant Attorney General Catherine Kelly joining us to discuss their office's enforcement of Governor Walz's eviction suspension executive orders. So as always, there were a number of questions submitted in advance, and so we'll get to those towards the end. But if you do have any questions, feel free to submit them over the Q&A system or in the chat. We'll be sharing resources and information relevant to what we're talking about in the chat as well. So with that, I guess I'll hand it right over to Joel and Alyssa.
Thanks, Eric. Yeah, this is Joel from Minnesota Housing. I will ask Alyssa if you want to go ahead and introduce yourself first, and then I will introduce myself and lead us into the PowerPoint.
Hi, good afternoon, everybody. My name is Alyssa Wetzel-Moore, Community Development Director at Minnesota Housing. Thanks so much for letting us speak to you all today.
Thanks, Alyssa. And as I said, I'm Joel Selzer. I'm the manager of our housing stability team at Minnesota Housing, which deals with our grant-based programs, our supportive housing units, and then our work out in the homeless response system, working with communities and stakeholders. The COVID housing assistance program came to Minnesota Housing and then funneled through my team. So I'm happy to be invited to provide a brief overview of the program. I'm going to try to go through the slides as quickly as possible, as I imagine folks will have some questions that they want to get asked and answered. So I don't want to spend all my time speaking to you. So let's go ahead and get into it. Here, just want to let you know, and presumably, Eric, this slide deck will be made available for your attendees, so the hyperlink should work. The first link there will just bring you to Minnesota Housing's webpage, where all of our centralized communication around COVID is being put. The second link will bring you specifically to the housing assistance page, where Most of the information I'm talking about today and a whole lot of other stuff will be listed there for you to go through as well. Two main points I want to emphasize with the Housing Assistance Program is that it is designed to keep people in their housing. So it's a prevention program, and it can support households who have a past due housing bill, housing related bill. So, well, it's not perfect in that it can't necessarily help somebody who is projecting to be behind or knows they won't be able to pay their next month's rent. It can't support those families, but it can support anybody who is in housing and has a past due housing related bill. Next slide, please. We were allocated $100 million. We wanted to use our network and our providers to distribute these funds. So we held a competitive application. We selected 44 administrators that did provide statewide coverage. Those 44 did include 7 tribal nations and several culturally specific providers, some of which who we have worked with in the past and some who were brand new to us and us to them. So that has been good. Last thing about the overview is that these funds do have to be spent by the end of the year. So, well, if current rates keep at the trends they are, that won't be a problem. But one of the ways in which we designed the program was to ensure that by through November, the funds would have at least identified and associated with applicants, and then we could have some time to get disbursements out. Next slide, please. We wanted to share that they're both at the directive of the governor's office and our Commissioner Ho at Minnesota Housing. This program was designed in ways that brought racial equity to the forefront in ways that we have never done before. And Alyssa would be able to speak to some of that as well if we want to dig into that. But both in terms of how we marketed the program, who we got feedback from to create the program design, how we scored, how we created a scoring rubric that would give points and value to different kinds of expertise that we haven't in the past, all as a way to ensure that those providers that we would ultimately work with could meet, at least to a certain degree, the variety of folks in our state that we want to help be served. At present time, there is no cap on the amount of assistance that can be requested. I'll talk a little bit more about the centralized intake process that we created for this program. Pretty unique, something we've never done before. It's, a week and a half into it. We've got some bumps along the way, but overall it's gone far better than I think any of us could have predicted. I'll talk a little bit more about that later. We are making our forms and program material available in English as well as 3 other languages, Hmong, Somali, and Spanish. And then we're also working in concert with like our COC coordinators, and other homeless prevention network organizations, so that this CHAP work or these CHAP resources are not being done or being deployed in a silo. We're doing it with partners advising us. So the things that are housing expenses, or we refer to them as the housing related expenses, include the things that you see on your screen. It includes, some expenses that are both for a renter focus as well as a variety of home ownership focuses. Utilities are allowed. By utilities, we do not, cell phone and internet expenses are not considered utilities. We've had a lot of those questions in the first week and a half, so I'll share that. Next slide. So who can participate is the crux of the program. We tried to keep it very clear and very simple. You do have to be a Minnesota resident. You have to income qualify, and that's being at 300% or below the federal poverty guideline. As I mentioned earlier, you must have a housing related expense that is past due. And then the reason why you can't make that housing related payment must be due to a COVID issue, to attest that you've been impacted by COVID, and that's the reason why you don't have the income to pay. So those are really the 4 key eligibility criteria that we look for. There's really nothing else that is a barrier for folks to get into the program and be eligible. Along the same lines, we've tried to keep a really hard balance of having enough evidence and proof that a cost is legitimate, balanced with this being as low barrier of a program to access as possible. Those really 2 are on the opposite ends of the spectrum. So we aren't going to be able to achieve 100% one or the other. So it is a little bit of both. I think we found a fairly happy medium. The first is that we do need a personal identifier. This just needs to identify that you are a Minnesota resident. It can be any number of ways to provide identification, including a numeric number that the client themselves can create on their own. There also is an option that says, I do not have a way to personally identify, and we can work with applicants who do find themselves in that spot. So again, although the bar is to have some kind of identifier, if that can't be the case, our administrators can work with that person one-on-one to see what else we can do. We do need pay stubs. We do need to show what the past 30 days of income will be. So that will need to be provided. The bill, the invoice, whatever it might be, stating that there is a past due amount needs to be verified as well. And then we're going to need contact for whatever organization or entity the check is going to. The payments are not made directly to the individuals. They are only made to the organizations who has the past rent or past housing expense due. So now I'm going to talk a little bit about the central intake process. If you want to advance to the next slide as well, you can see here that there are basically 3 ways in which anybody across the state who thinks they're eligible or wants to apply can. They can either use the 211 number or the 800 number. As we know, the 211 number doesn't always work in all areas of greater Minnesota. They can also visit and go online to complete the eligibility application, or they can text MN Rent or MN Home to that number, and that will bring them to the online version as well. So 3 easy ways in which folks can be told. It's all streamlined basically into one entity, which will then collect all of the eligibility and interested individuals, who will then be sent to the providers of their choice. And I can speak to that next if you want to advance the slide. This is a little bit small here, but a visual description on the left-hand side of what I just said. You see the seekers on the left-hand side. There's a variety of ways in which they can get to the pre-screening eligibility. And again, the pre-screening eligibility asks basically those 4 questions. If they're found to be not eligible, they'll be referred out. If they are eligible, they'll be asked an additional set of household questions like phone number, email, have you been homeless before, address, and then they'll be allowed to select a provider who is providing services in their area. And then once they selected that provider, that their application or their notification will be sent to that organization, and it will get in the queue for that organization. And as that organization serves more, their application will then come to the top of the line. They'll reach back out to the applicant and begin working with them to complete the more full application, which is described a little bit on the next slide as well, if you want to advance. Like I said, clients will complete the application online, and the full application, they can get assistance from their provider if they need or want that assistance. The verification that I talked about before, all of that can be uploaded, or pictures, you can take a picture of it and upload it. It does not need to be paper copied. We try to make a variety of ways in which folks can submit their documentation as easily as possible. And then once the application is done, that's when the provider can assist the client with securing additional verification. particularly with those entities that are owed money. You know, if there's past dues, fees, or late fees, sometimes the provider will try to negotiate those to be gone in exchange for a full payment. So that can be where our providers are spending more time to help remove some of the barriers and some of the costs for these households and individuals. Next slide. This is just last slide, I believe, and just wanted to let you know some key information about the implementation of the program. We launched it a week ago Monday, so we've got 5, 6, we're 8 business days into it. Through Saturday, there were about 2,000 texts that were sent to the 2 options. Through Friday, there were about 4,000 calls. The average wait time was about 2 minutes, and the average call length of each phone call was about 10 minutes. Through this Monday, we've had about 10,000 applications that had requested just under $13 million. As of Monday, there had been 113 payments made at about $130,000. So you can see there's some pretty big discrepancy between those who are applying and those who have been approved for payment made so far. We did anticipate that when it was launched, we'd have several weeks of extreme high demand. And although we do have 44 providers across the state, 44 providers can't handle 10,000 calls in one day, or excuse me, 1 a week. So we knew that we'd have some ramp up time. As I said, overall with this system, it's gone relatively well. There are certainly bugs we're working out and problems that we're trying to find solutions to. But for the most part, access to applying has not been a problem, which was one of our main goals. And then being able to get through the eligibility application and full application appears to be going well, again, as we can see by the north of 10,000 applicants. I think that should be it. Yep. So happy to pause here. I'm going to take a moment and invite Alyssa just to share a word or two about the program, and then be happy to stick around for a little bit to answer any questions that you guys might have. Alyssa, is there anything that you'd like to share before we open it up for Q&A?
Yeah, sorry for the delay. I've been having some internet lag time. Yeah, I would just say high level, we just really appreciate your assistance in helping us get the word out. Please stay tuned because we will be posting some additional translated forms and things, as Joel has said. Again, don't hesitate to reach out to me if you'd like with any questions or concerns, and I can help funnel those or get those in the right direction. I do see a couple questions from the Q&A where someone says, if someone lost employment, how can they provide proof of income?
Right. So in that case, what we'd be looking for is any pay stubs that would have been earned and provided over the past 4 weeks, even if it's partial. However, if they've lost or if they don't have any income, then there's a way for the household to attest to that, and then no income would be needed to be verified because there is none.
And then another question I'm seeing is, I'm running into issues with some resources wanting to send to the check to the individual on the W-9. Do you request a W-9? If so, can it be considered that you send the check to the property manager?
I'm not sure I totally understand the question, but if it's, we are restricted to sending the payment to the entity that it is owed. So if there's a way in which the property management company is responsible to collect that rent, they can. However, the required owner documentation would still be needed, like the W-9. We have heard that that's probably the most challenging document that of anything. That's probably where most people are spending more of their time trying to secure that. And sometimes it does take a while. Sometimes it does take several phone calls. It does take several days. So we know that that has been challenging, but we're working with our providers to help them make those calls and stay at that for as long as possible, because we are required to provide those things because this is a federal program.
Right. And that was the follow-up question. Do we require a W-9? It sounds like yes.
Yes.
And then And then the next question I see here is, would a person receiving other forms of public assistance, such as housing support /GA, potentially be eligible for the housing assistance program to help with a large past due utility bill? This large charge is from March to June and is beyond the normal housing support budget.
Yeah, I would say that in, earned income or entitlement programs always sort of are cause nuances to be fleshed out, and sometimes we aren't sure. I would highly encourage that you encourage your clients, potential applicants, to at least go through the eligibility process. There are certainly households that do have support, such as housing support, that they can use the program for it, not only for the, in this case, the rental costs, but the utility aspects can be paid for in certain circumstances as well. So do not let that prevent somebody from at least applying.
And then someone wanted to clarify rental assistance. Someone's only entitled for rental assistance through this program for rent owed on or after March 1st.
Yes, yeah, thank you for whoever is pointing that out. That's help to us. Any expenses incurred prior to that, even if it was COVID related, these funds cannot be used for those expenses. They would need to be itemized out so that expenses related only to those as of April 1st or later could be eligible for repayment.
And then I'm seeing one more question, and I'll put in the chat again that link to the website where tenants can apply. The final question I'm seeing is, households that are in subsidized housing, they ended up losing some work due to being exposed to COVID and had to quarantine per employer's policy. Any recommendations where these households can go for help since they don't qualify for this assistance?
I think that in instances where somebody isn't going to qualify for this program, county EA and EGA are still prime sources to go to. And for those of you that are familiar with the Family Homeless Prevention and Assistance Program, those funds are, those grantees are still operating the FHPAP program, which does help with the kinds of scenarios that this person is describing. Again, if somebody's in an assisted program where their rent is going to be adjusted because of the loss of income, they may not be great candidates, but there are some situations where people are living in rent subsidized units that doesn't adjust with their income. And in those cases, those tenants are eligible to apply for this program. So they should go through the application process.
Thanks, Joel. And the governor's office does also have a web page listing a number of different types of assistance. I'll also put that in the chat as well. I'm not seeing any further questions. Again, look in the chat again where people can access this resource as well as other resources available through state agencies.
Thanks. Thanks both to Alyssa and Joel for covering this. There's one question that was sent in advance. I'm wondering if you can touch on in this last minute here. We got a question about how might COVID rent relief affect someone who hasn't been able to pay due to domestic violence?
Yeah, I think that if there's an underlying connection there to COVID, that would make sense. If the reason for inability to pay housing related costs is exclusively to domestic violence and there's not a tie to COVID there, then that household would not be eligible for these funds.
I am seeing one final question here. It says, we are a grantee for the FHPAP funds, however, we do not, looks like have the funds needed for the number of clients asking. So are we able to use this program in addition to FHPAP funding? And I think this is the final question.
Yeah, if I understand it right, and then to put it in the context of my own words, I think what we're likely to see, certainly with CHAP, and we already know this with FHPAP allocations, is there is never enough resources to meet the demand that you providers are facing. So while we'd like to say, yes, we have additional resources for them, we don't at this point. We've got the $100 million for CHAP, and then what we've been allocated through the state legislature is what we have for FHPAP. These two are different programs, so blending of the resources would not be something that we'd want folks to go through. But being able to, but because FHPAP certainly is has a prevention aspect to it, it can serve both prevention and the housing assistance placement. If you're a provider and you're feeling like you might need to adjust your work plan or your dollar allocation between prevention and housing placement dollars, feel free to reach out to Nancy or Diane, the program staff, and they'd be able to help revisit that work plan with you if you think that would be best for your community.
All right, well, thanks again. I'm gonna put, again, if people do have additional questions about the logistics of the program, it sounds like the email address that's up on your screen, mhfa.covidhap@statemn.us, that's where they should go for these kind of logistical type questions. So yeah, again, we want to thank both Joel and Alyssa in Minnesota Housing for joining us today and covering this topic. Is very important to a lot of folks on the line and our clients and service providers throughout the state. So thanks for joining us, and I think next I'm gonna hand it over to Mike, Homeline's managing attorney and hotline director, Mike Vraw, to introduce our next speaker.
Thanks, Eric. Why don't you go on to the next slide if you could? Okay. Yeah, so for the rest of our time today, a little bit over an hour, we're going to be chatting with Assistant Attorney General Catherine Kelly. I've known Catherine a long time. I think, wow, I'm trying to figure out exactly when this would be. I think it would have been back in the 90s is maybe when we met. Maybe I'm wrong about that timing. But it was certainly when Catherine was an undergrad and she started volunteering in our office. And look at her now, an Assistant Attorney General, and she's working on the housing issues that have become so front page news in the last 6 months. So welcome, Catherine. I know you've got sort of a set presentation, but we already have a list of questions in line for you. And so I'll let you go through the prepared materials, talking about what the AG's office is doing right now, and then we'll get to the questions.
Absolutely. I'm happy to do that. Can you hear me okay?
Yep, we can hear you fine. Thanks.
Okay, great. I too was racking my brain. I'm going to put it that we met in 2002. So
okay.
Almost the 90s, but I could be wrong. Okay. Long time. So yeah, so I'm Assistant Attorney General Catherine Kelly. I have been with the Minnesota Attorney General's office for about 6.5 years, coming up on 7 soon. And I practice a variety of consumer protection law. I'm specifically in the Attorney General's Consumer Protection, Wage Theft, and Antitrust Division. It's a large division that's focused on protecting the rights of consumers in Minnesota. So let's kick it into gear. What is it that the Minnesota Attorney General's office does to enforce Governor Walz's executive order on evictions and housing and rental? Great, thanks for that. So our authority comes to us explicitly from the governor's order. So the one I'm talking about today is Executive Order 20-79. There's been a few iterations, but this is our current one. And it expressly provides for our authority. And I included the paragraph there for those on this webinar who want to see it. But at the end, after talking about the criminal violations, which my division does not enforce, we do not have criminal penalties, we only have civil. It then provides that last sentence, which says the Attorney General may also seek any relief available pursuant to Minnesota statutes, section 8.31. And if you go to the next slide, I have another thing to point to. So if the governor's order did not provide for our authority, we would still have authority under our statutory authority. So Section 8.31 is the one that gives the Attorney General his consumer protection powers, and we would be able to enforce it even if the order didn't say you have the right to enforce it. And I just put in the statute right there. When we bring cases against companies that rip off consumers, against mortgage companies for mortgage violations, this is the statute that we point to, and so this work falls into that very well. Next slide. All right, so how do we enforce the order? So it starts with a report from someone in the public. We do not have any independent knowledge of what's happening in the landlord-tenant marketplace without receiving input from that marketplace, and that's true for all of our enforcement activities. So currently, tenants can fill out a form on the Attorney General's website. We have a dedicated form, and I'll get to that in a second. So we have a form that is filled out, but also if someone doesn't have access to a computer or you know, a lot of times I gotta say tenants are out and about, they're in the yard and they don't have a computer, they have a cell phone, so they can just call us as well. We have a phone line dedicated to taking calls. They take them all week during specific hours, and you can input that report through the phone if you do not have access to a computer. We highly recommend the form get filled out if you can, because it has very specific fields that are very helpful to us in our enforcement activities. So I encourage anyone who's able to fill out that form. Let's go to the next slide. Okay, so this is just a screenshot of the current iteration of the Minnesota Attorney General's website. And you can see there at the bottom of this picture that that is where our eviction form is currently. Below that is some other forms that people can fill out. And I'll take this little moment to actually say, if anyone's having a consumer concern of any kind, they can always come to our website and fill out a form, not the eviction one, but the other one that says file a complaint. So that's, you know, if you were overcharged for something at a store or false advertising or something that's a consumer protection concern, feel free to fill out that form. It does two things. First, it notifies us of what's happening in the marketplace so we can see if there's a pattern of a company doing a specific illegal practice. But it also allows us to then try to mediate the complaint for you. And that's where we contact the company. We say, this is what's happening. Can you assist or can you remedy this concern that the consumer has? And then we are the go-between. That's a voluntary process. Companies don't have to engage, but a lot of times they do, and we can sometimes achieve some pretty good success through that. So I wanted to hijack this webinar just to give a shout out for that form. So the eviction complaint form gets filled out by the tenant, and then it comes to us. We'll go to the next slide. Thank you. So after it comes in, it then comes to the evictions team. And when I say evictions, I mean the team that's enforcing Governor Walz's order. So we review the complaint form looking for a violation of the governor's order. That is what this team is meant to do. It's not meant to you know, mediate a repair problem or something else that a tenant's having. It's very much geared towards keeping someone sheltered who should be protected by the governor's order. So then what do we do with that information once we have it, whether it's on the form or it came in through the phone room? It comes to us. We then contact the tenant and the landlord. A lot of times the tenant hadn't given us enough information about the specific facts of their circumstances. And so we need to contact the tenant. We also want them to know we received the report, we're working on it. And then we contact the landlord. Contacting the landlord is critical. Our form specifically asks for your permission to contact the landlord. We recognize that sometimes the tenant just wants to talk to us or wants some advice, and they don't want to ruffle the feathers of their landlord, or for whatever reason, they don't want us to contact the landlord, and we honor that. We don't contact the landlord if they're saying not to. I know from my own experience and from our files that sometimes that can cause more harm than good when the government calls your landlord. So we do respect that if you see that on our form. So when we are able to, we contact the landlord. We find out their facts, their circumstances. We try to see what it is that they've done and how they characterize it. And we really try to obtain their compliance with the governor's executive order right then and there. It usually involves a lot of education with the landlord, informing them about the order, applying the specific facts in this situation, and telling the landlord how the governor's order applies to it. And it can be a lengthy procedure, and it's carefully done by us, but it's very effective. So that's generally how our enforcement goes, and we'll go to the next slide. Okay, so we get asked this a lot, so I wanted to make sure I covered it. So complaints to the Attorney General's office are categorized by statute as private. We cannot give them out to the public. If somebody called us up and said, I want Jim's complaint form, I heard he filed one, we cannot give it to that caller. We can only give our data back to the citizen, the tenant who asked for it. So I just wanted to make sure everyone understood that, because we get that request a lot. We do not ask for a tenant's immigration status. Frankly, it doesn't even occur to us to inquire. It's not relevant to the situation. And as far as I'm aware, it has never come up. And so I encourage everyone to reach out to us, even if they're worried that we're going to delve into that. We don't ask. The form can be filled out by a tenant's advocate. So we do see this fairly often if it is, let's say, for example, the Office of the Ombudsman. So if they're helping somebody who's in an assisted living facility and that resident is potentially being pushed out of the home in violation of the governor's order, the Ombudsman's office will file that complaint form for that resident who's not able to do so. The complaints we get. So I want to just cover what we're hearing and seeing and learning from the marketplace. So the category of complaints are most generally, my landlord has said I have to leave and I can't. We don't get complaints where tenants are happy to leave, right? They don't report that to us. I'm sure it's happening in the marketplace, and that's fine. It's when tenants need to stay that they report their concerns to us, and that's when we take action. So usually it takes the form of a landlord telling the tenant they have to leave. That could be a 30-day notice to vacate. It could be a letter that says you haven't paid in a few months, you have 5 days to pay or get out. Or it could be a text message that just says get out, right? This happens a lot. It's a lot of informal communication between landlords and tenants. Sometimes it's oral. Sometimes the landlord shows up and pounds on the door and says, you need to leave, you need to get out, I want to re-rent it, or I want to do X, Y, Z. In all those circumstances, that could very well be a violation of the governor's order. So those are kinds of the varieties that we're getting. Some of the reasons that landlords are giving us for doing so is, well, the majority of it is they didn't know that the governor's order applied to them. Also, a lot of them are saying that they want to remodel the home or they want to sell the home. They have to get the tenant out. Other times they just think that they can't go to court and evict because everyone calls it an eviction moratorium. But it's not just evictions, it's also any attempt to terminate a tenancy. That's against the governor's order. So a lot of landlords that we talk to say, well, I didn't know it applied to my letter. I know I can't go to court and evict them, but we have to educate them and say, well, that letter alone is a violation. And that makes sense because tenants who don't know their rights or busy get that letter and they might just leave not knowing that they're protected. So just sending that letter is a reason for our office to contact that landlord and ask them to retract it. We'll go to the next slide. Thank you so much. So as of now, we have received over 1,300 reports from tenants that their landlord is violating the executive order. And the vast majority of those are like I said, landlords who didn't know what they were doing was illegal. We get a lot of very nuanced complaints that are very, very fact specific. And so we get a landlord who says, I didn't know it applied to an oral lease. Or we don't have a lease, I'm not ending a lease. They've just been living there and they pay me money. So, and a lot of those people on this webinar know that is a tenant, that tenant is protected. And to be clear, the governor's order applies to protect tenants. And that's often overlooked as that's the goal of protecting tenants. And I say that because we run into the situation where we are contacting hotels, we're contacting assisted living facilities, we're contacting sober homes, and there's boarding houses, that's another category. depending on the person's situation, they could be a tenant. And if they are protected by the governor's order. So that's why I say we have a lot of discussions with landlords trying to tell them what you're doing is against the rules because this person is a tenant. So our success rate is actually very high. The vast majority of landlords agree with us that they can't really do what they were trying to do, and they agree to stop doing it. And stop doing it can take the form of contacting the tenant to say, never mind that letter I sent you saying you have to get out. Something like that, something to retract the demand to get out, and making sure that the tenant is comfortable knowing I can stay, even though my landlord gave me this letter. We then follow up with the landlord in writing. We send a letter that memorializes the agreement that the landlord made. That way, landlord has some information in their hands about what it is their responsibilities are under the law. Tenant has something in their hands that tell them what their rights are under the law, and they have some comfort to have a piece of paper that says landlord is going to comply with the rules. And so that's a document we send to both parties. We also keep copies for our files, of course. So even though we're successful, the majority of the time, there are landlords out there who are not swayed by our powers of persuasion. And every now and then we come up against them. And so we have tools in our toolbox to enforce the order in court. We have done so 6 times so far to date. And in all 6 of those occasions, it was where the landlord gave a notice to the tenant to get out for any number of reasons. Then tenant said no, or I can't. And then landlord engaged in self-help. They just tried to force tenant out on their own. And that takes the form of turning off electricity, not refilling propane when it's still cold outside, locking the doors, in taking some action that actually prevents the tenant from living there, forcing them out. And that's an act in furtherance of terminating a tenancy. It's a constructive eviction, and it's a violation of not only landlord-tenant law anytime, but it's also a violation of the governor's order. So we've brought 6 of those cases all over the state. These are not metro focused. These cases are in Pine County, in counties I had never heard of before. So it's not unique to the cities at all. 4 of those cases have settled now, and in all 6 cases, the judges agreed with us that what the landlord did was a violation of the governor's order and issued an emergency order restoring that tenant's, housing, whatever it was that was missing, electricity or change the locks or propane in those cases. Next slide, thank you. So I talked fast because there's a lot of questions, so I'm just giving sort of the high level and then we'll address some questions. So the governor's executive order on evictions and tenancy terminations is based on his foundation of his power, which is declaring a peacetime emergency. And his peacetime emergency gives him those powers to create orders that say, you have to wear a mask in a restaurant, or you have to house a tenant, or you can't have large gatherings out in public. He gets this power from the peacetime emergency declaration. Those come in 30-day increments, and the next 30-day increment is ending on September 11th. So that means between now and September 11th, the governor's eviction and tenancy termination moratorium continues. I encourage everyone to watch the news or watch the governor's website to see if he extends it another 30 days. If he does, and he doesn't otherwise modify his executive order, then the rules that we're under right now for the executive order apply to the next 30 days. They just keep on rolling while the peacetime emergency rolls. So I put on this last slide, future housing executive orders, and that's because we really like to make sure people know, including landlords, including tenants, that it could change. He could change it at any moment without a lot of notice. Maybe there'll be notice, maybe there won't, but he has the authority to change them. And so your protections as of right now might be very different in September. And this conversation often comes into play when I talk to tenants about rent. And they say, well, I'm probably not going to have to pay rent for, the winter. And I say, we don't know that. No one knows what's going to happen. If you're able to pay rent, you should pay rent, because once the protections are lifted, then you might get evicted. and it'll be very difficult to catch up when those protections are lifted. So I just encourage everyone to watch to see if the orders are changed and to see if your status or your protection changes. So with that, I'm happy to take some questions.
Okay, well, we have 7 or 8 questions that were submitted in advance, so we're going to start with those, and then we'll get on to the Q&A submitted ones, and people can submit them there or through the chat box, but I think we have enough to fill most of our time here, so let's get started. From Suzanne, this was in advance, if a person has a month-to-month lease, can a landlord choose not to extend it during the peacetime emergency? Not evicting, but it trails off there. So
Yeah. Yes. So the question is, you know, if you don't formalize your relationship, are you still protected? That's how I interpret that question. And before I answer, I'm just going to give my disclaimer that, you know, the Attorney General's office doesn't give legal advice. That's actually Homeline's strong suit, but happy to ask general questions. So in general, regardless of whether you have formalized your relationship, if you are a tenant, if the law considers you a tenant, you are protected from having your tenancy terminated. And that could take the form of landlord saying, I'm not going to renew your lease. You have to get out. If let's say that was September 1st, and yet here we are September 2nd, and you stayed, you're a holdover tenant, but you're still a tenant and you're still protected by the governor's order.
okay. Similar question, but slightly different angle. Are holdover guests who do not pay rent or provide services covered by the governor's order limiting eviction?
Right, so guests are not tenants. And that questioner asked that question in a very specific way because they said, if you don't pay rent or provide services. And the reason that person included that, I'm assuming, is because that's actually the definition of a tenant. It's somebody who has housing in exchange for providing rent or services. And without that component, you're not a tenant, you're just a guest. Guests are not protected by the governor's order.
Yeah, tenants and landlords are both actually defined, literally defined in state law. Eric, if you could put up 504B.001 for people to see in the chat box, they can look up the definitions of landlords and tenants, and you'll see that it's pretty broad, as Catherine just said. Do they pay rent or do they perform services? And if so, then they probably have the rights of a tenant. All right, from Ashley. Again, a slight different angle, but can landlords not renew leases? Tenant has not paid their rent portion, but Section 8 has.
What was the first part of that question?
Can landlords not renew leases? The tenant has not paid their rent portion, but Section 8 has.
I think that's an interesting question because it just reminds me that it's such an interesting time we're in right now where it's actually tenants who receive assistance like Section 8 are some of the most, you know, sought after tenants by landlords right now because they have a guaranteed source of income. So anyways, I'm glad we're having that question and that comment because in that case, the landlord is getting paid. But either way, even if Section 8 hadn't paid, non-payment is not a basis to ask a tenant to leave or evict, go to court and evict. And I think the beginning part of that question was if the lease was not extended. Again, doesn't matter if your lease was voluntarily extended. If you are in the home and you previously were a tenant, it doesn't matter if you've paid or not. The landlord cannot remove you.
Well, we could go a little further with that concept. What if the tenant, Section 8 has a lot of regulations, some for the landlords, but many for the tenants as well. What if the tenant lost their Section 8 voucher completely? Would that give the landlord the right to evict now?
No, it would not, because non-payment, no matter where the payment was coming from, is not a basis to terminate a tenancy or evict.
Okay. From Katie, I'm going to try to get this one. What if someone's lease expires at the end of August and they can't pay September's rent due to loss of income from COVID? That's all she asks. So I'm not exactly sure if she's asking, can an eviction follow or a notice to vacate, but I'm guessing that's where she's going with this. And having done these a few times before, you get some duplication of questions, but it also lets you know what people really want to know. It sort of emphasizes things. So it might be a brief answer, but I'll let you take it.
And that's okay because, you know, she might actually just be asking also, what do I do?
Sure.
Like, what are my protections, but also help me, what do I do?
Right.
It's great that we had that presentation at the beginning to apply for assistance. I'm just going to repeat it. If you want to call 211 to apply for rental assistance, if you have a housing payment that you haven't been able to make due to COVID since March of 2020, and you're behind on rent, or you're behind, even for homeowners, if you're behind on your mortgage payments, call 211, see if you qualify for some of the $100 million that's available for rental assistance. So yes, to this person who asked the question, you can stay in your home. You can't be removed by the landlord legally. And if your landlord is trying to, please contact the Minnesota Attorney General's office, but also reach out to these resources to see if rent can be obtained for the landlord. Again, I'd like to just emphasize that it's worth making those efforts to get rent, because even though you are protected right now from being evicted for non-payment, that eviction protection might go away. I'm just going to interject here that there's been some breaking news in terms of eviction protections from the federal government. So I'm sure Homeline is going to be covering this as it unfolds and we all learn about it more. But the CDC has issued new rules protecting tenants nationwide from eviction. The protections are very narrow. They're not nearly as broad as Minnesota's protections. So our state rules are still more protective, and I'm glad we have them. But my point is, at some point, these protections are going to end. And if you are doing all that you could to keep up with rent now, even when you're protected, when the protections go away, you will be able to protect your credit score, right? You'll be able to protect against eviction. So it's worth reaching out to these resources if they're available.
Yeah, you just mentioned the CDC order. Both the CDC order and the governor's orders, which have consistently said this since March, have insisted that the rent is still due. There's no rent forgiveness. There's no rent cancellation. So yeah, I mean, the rent is clearly still in place. New topic from Abby. How do landlords enforce the mandated mask order on tenants? What do we do about tenants in violating the order?
It's a good question, but it's one I can't answer, because although the Minnesota Attorney General's office enforces many of the governor's executive orders, including on public activities and events, there are different attorneys in our office who do the mask work, and I don't know what their guidance is or what they're enforcing, and I apologize to this person. But the Minnesota Attorney General's website has a generic COVID-19 complaint form, and any member of the public can go there and fill that form out. And this to me sounds like a great question for that form. Just what do I do about this COVID-19 related issue? And I believe it will go to a department in our office that will reach out and provide that guidance. And I'm sorry I can't do so today.
It's hard to believe that there's somebody out there that currently is a mask attorney, that that's a specialty in the law. But I believe you that it probably is. There's probably dozens of mask attorneys around the country at this point. Wow, the times we're in. From Vang.
To jump into,
sorry.
Mike, I did put our FAQ, Homeline's FAQ on mask.
Thank you.
The mask requirements in the chat.
And Eric does this throughout these sessions. He'll list lots of useful links in the chat box. If you have that open, then that's where you'll find them. If you don't have it open, I'd suggest strongly to do, because it's sort of a map to look at things that, that we're talking about real time. From Vang, are there any restrictions to tenants who would like to have a door camera inside/outside of their apartment door? Not what I expected today, but.
People ask, if they've got someone, they'll ask a question, and I understand. I do the same thing. So I can speak to that issue. That just sounds to me like a landlord-tenant specific question. Mike, since we're here, would you like to answer that question?
Sure. I think that inside an apartment, a tenant can probably put a camera pointing out, as long as it's not designed somehow to look through somebody's blinds. They've got some special gizmo or infrared look through somebody's walls or something like that. But if they wanted to just look out the area that they could see through their own eyes, they can probably install a camera inside their own apartment. Installing it outside the apartment, that's a different level. And it depends on how you do it physically. If it can be done wirelessly, I guess the argument's a little bit stronger for being allowed to do it. But if it's got to be wired, that might be a destruction or alteration of the property, which a lot of leases don't allow. So it's one of those things where I'd recommend that Bang contact our tenant hotline directly, assuming that Bang is the tenant, and we'll try to get the specifics. But let's go on to Emma, who's actually asking about the CDC ban. Who's covered under the CDC eviction ban? Will this ban also protect month-to-month renters from landlords who don't want to renew? How much have you looked at the CDC ban at this point? It was released, just so we all know, 16 hours ago, maybe, 37 pages. I've read through it a couple times. How about you, Catherine? Have you had a chance to dive in?
I'm pretty similar to you, and also to point out, because we're lawyers and we have to care about this, but it's preliminary. It's not the official publication yet, so it might change. Just FYI, everybody. So yeah, I've only skimmed it just to know, A, that our protections are much stronger. The federal protections require tenants to jump through a lot of hurdles, a lot of certifications, attesting to an impact from COVID and what the level of impact was. It also very clearly carves out people who reside in hotels, and I think it said like seasonal facilities. So it's really geared only to apartments and houses, whereas in Minnesota, the governor's order applies to a tenant no matter where they reside. If it's, in a hotel because they're there long-term, et cetera. So Minnesota's is still more protective. And I did not see a definition section that said who it applies to, whether it's, like the CARES Act, where it's only if you have a federally backed mortgage, or if it was just a straight up rule. That's kind of what my takeaway was. But Mike, if you have any info, you're welcome to add it.
First of all, on the hotel or motel, it was a question that I had reading that order as well, and because of Minnesota's really expansive definition of a tenant. I'm not sure how that would play out. I think the CDC order might have to defer to the state definition, the expansive version. So I'm not sure that a hotel or motel would be exclusive or excluded automatically. I think it would be an indication that it should be considered to be excluded, but fair point. The broadness of it, though, the bigger question, the CARES Act, which was the other federal protection we had that expired, I guess, officially July 25th, was limited to federally subsidized type places, along with places where a landlord had a federally backed mortgage. As near as I can tell from the CDC ruling, it does not have that limitation. It seems to be every American tenant, except for, of course, those tenants in American Samoa. And I'm not kidding, because there's been no COVID cases in American Samoa, so they are exempt from this order. It's the one place in the United States or territories where it doesn't apply. We're probably going to spend a lot of time talking about the CDC order next week. In my mind, the only thing that really matters for a Minnesota renter or landlord when thinking about the CDC order right now is the governor's order expires September 11th. You are in a much better position to know whether the governor is going to renew that than I am, but I don't think you know if the governor is going to renew it, and you probably wouldn't tell me anyway. But if a tenant is asking, or a landlord is asking, what happens on September 12th, the short answer is going to be, for me right now, well, the governor's order might be extended, as it has been since April, but the federal order is in place through the end of the year after Friday. Like you pointed out, it isn't the rule yet. It doesn't take effect till September 4th when it's officially published, even though it's published already. You can see it. It becomes officially published on Friday. Are there going to be constitutional challenges? I would assume so. I've never seen anything like this. I mean, the first instinct that every tenant advocate I know of that had when they saw this is, the CDC can stop evictions? That seems phenomenally unexpected, that the CDC would have the power to be able to stop evictions. I guess it makes some sense from hey, there's a pandemic threatening everybody's life, so maybe the CDC should have some extraordinary powers. But I assume some landlord, and if I had to bet money, I'd bet it's going to be a Texas landlord, will be suing to challenge this at the federal level. And so we'll get some sense of that, although the state rules might have an impact on how that works out. But that is, and I think it will absolutely protect month-to-month renters. But it does only work for non-payment of rent, though, just like the CARES Act did. So the breaches of a lease, an unauthorized occupant, the boyfriend living with somebody, or a dog when there's not supposed to be a dog are protected under the governor's order, but they're not protected at the federal level. So there are some key differences that if the governor's moratorium gets ended, then that's the end. But again, the state moratorium in place, the federal moratorium defers to the state moratorium explicitly. So that's the first hurdle a landlord would have to look at in deciding whether they can get to the eviction center. By the way, I'm really thankful that I'm not a tenant lawyer in Pennsylvania today. Their eviction moratorium, their state eviction moratorium ended on August 31, and there's this 4-day window between then and when the CDC order comes into play. And apparently in Pennsylvania, it's just a mad rush to the courts for landlords, as one might suspect would happen. But anyhow, you would not be enforcing the CDC order. It looks like that's the Department of Justice. I don't think that your office would have a role in that at all. Is that your sense of it?
So I did only just skim it, but that was my high level takeaway before I dig into it further. It's similar to the CARES Act, where they did not delegate or assign authority to the states. There are many federal laws that do give state AG, state law enforcement authority to enforce the federal law. It wasn't in the CARES Act, and I didn't see it in my quick reading of the CDC rulemaking rule.
Sure. Well, neither one of us thought we'd be doing that on a Tuesday night, but there we were, staying up late reading CDC edicts. All right. Can an owner give tenant 2-month notice to vacate, to move while a tenant is on a lease?
I understand that one. I can take it.
Go ahead.
Yeah. And I can take it because I talk to so many tenants. So when I hear those words, I kind of already know what they're thinking. And if I'm not answering this person's question, I apologize. But here's what came to mind that we see a lot. And this is in that category of landlords saying, I didn't know I couldn't do this. And it would be, the hypothetical is the lease ends October 31st and mid-August, let's say landlord says, I'm not going to renew. So at the end of October, November 1st, you have to be out. And that's a letter terminating a tenancy in the future, but it's still an act in furtherance of terminating a tenancy. And the landlords say, we don't even know if there'll be a peacetime emergency then. I might be able to force that tenant out then. And our response is, that might be true. Well, okay, before CDC came out with their guidelines, that might be true, but your letter right now is a violation of the governor's order and you need to retract it. And the reason that that's important is because if you give a notice now to terminate a tenancy and your notice would otherwise be effective right now because you complied with whatever your lease's notice provision is, and the protections go away, you might be evicted or removed or be a holdover tenant like instantly because of that prior notice. And so it's important that we inform landlords that that notice was ineffective. It's void for being illegal. That's the position we take. And another reason why that's important for tenants and landlords to understand is the purpose of the governor's order is to keep people housed. We cannot be going out into congregate settings, into shelters. We can't, as the CDC's rulemaking guidelines said, some reports said that I think it was over 30% of families who were surveyed said, if I'm evicted, I have to go move in with other family, that's actually a low percentage. I would think it would be higher. And they know that families who are in close quarters are actually far more effective in transmitting the virus than even other congregate settings, which is interesting. So the point is, we want people to stay in the homes that they have right now. And if you're telling that tenant, you're going to have to get out in 2 months because we don't know if there'll be an evictions moratorium, that's going to cause that tenant to go out and start looking for new housing, maybe commit to moving, maybe get worried that they won't find new housing and just voluntarily leave and move in with family or go to a congregate setting like a homeless shelter. So that's why it's important that even if it's in the distant future, a notice right now to end your tenancy is a violation of the governor's order. So I think that's where that person was going, but I could be wrong, Mike.
I think that makes, I think you're answering it. I mean, what you're describing in a lot of your landlord situations are landlords that don't sound especially sophisticated or well-versed in landlord-tenant law. I'm not sure that's the image that most people have of landlords. If they're thinking of sort of a stereotypical, I mean, they think of a giant building in the suburbs with 1,000 units. That's not really who you're talking about here, right?
That's right. And that's actually not most of our files. So I can share that bit of data with you. Is at first we were getting, like, let's say the end of March, early April, actually all of April, we were getting a lot of consumer tenant reports reporting that their landlord was violating the order, and they were the very large companies, you know, the nationwide rental companies, or the large local property management companies that were violating the governor's order. And either they just didn't notice the governor's order came out, or tried to push the envelope at first, but then saw how hard we push back very quickly. And so those corporations, they have in-house lawyers, or they have outside counsel that they consult with. And for the most part, they are complying with the governor's order. It really, as you pointed out, it really is the mom and pops, the people who own 1 or 2 properties, or I'm surprised how many accidental landlords there are out there. People who needed to downsize and move into a smaller house or a 1 level because they were getting older, and for some reason either couldn't or wouldn't sell their original home, and so they rented it out. They have no idea what the rules and regulations are. That's why our enforcement work is really so education based. We are educating them on what the law is. And I honestly don't blame a lot of them, because the law changed so quickly on them and they didn't see it coming. So yes, it is a lot of small landlords who just aren't doing the right thing, a lot of times through ignorance.
Right. I mean, people that watch this every week, and there's a lot of people that do, we talk about the fact that laws in landlord-tenant world change, if they do change, very glacially. It can take months, years, decades before a rule that's proposed at some legislative level before it becomes an actual law. But now, I mean, you and I are people that make our living knowing landlord-tenant law in Minnesota. And if we were given a quiz on what the rules are going to be on September 12th in this state, if the governor gives a moratorium, we'd be guessing a little bit about some of this stuff. The laws are just shifting everywhere. And so for somebody that has a duplex, but they have another career that they work at most of the time, they're not going to be keeping up. That's honestly why we do these webinars, is we're trying to make sure that tenants and landlords, because we have about an equal viewing audience of both, are familiar with what the rules are, because they're changing so fast. So we've got a question from Lauren. She's asking specifically about AG stuff here, and I'm going to combine 2 of her questions. Has the AG's office actually enforced the misdemeanor of $1,000 or issued jail time of 90 days to the landlord since the beginning of the pandemic? Or is it mostly just a one-time warning? Also, how many complaints have been submitted each week since the governor's order has been in place? Very specific ask there.
Yeah, I'm happy to address them all. Okay, so I'll take them in the order that she put them.
Yeah, it was the $1,000 and 90 days first.
Yep. So the 2 different penalty sentences in the executive order, the first one is criminal. It's a misdemeanor and $1,000 fine. And then the second is a civil. And that is, it actually just references our statutory authority, but our statutory authority is 8.31. And that says, per violation, the Minnesota Attorney General can seek penalties up to $25,000 for 1 violation. So there are 2 different penalty provisions provided, and the criminal provisions can only be sought by a county attorney. That has to be local criminal law enforcement, not the Minnesota Attorney General's office. The Minnesota Attorney General's office does have a criminal division. I am not an expert in it in any way, shape, or form. I'm a civil attorney. My understanding is that they only take cases that are on referral, but don't quote me on that, please. So the short answer of it is the governor did not give the Minnesota Attorney General's office the criminal authority to put a landlord in jail. Oh, okay. So second question, how many complaints have we gotten? We have received a very steady amount of complaints, and it's very interesting. I really thought it would fluctuate, but in July and August, we received almost exactly 230 complaints each. And I think that's also true for June, right around that number. So it's very steady. And cumulatively, for those who joined us and didn't hear beginning, we're at currently over 1,300 complaints filed by tenants. And the majority of those do allege a violation on the face of the tenant's complaint, like what they're saying would be a violation. A few of them had nothing to do with the governor's order, so the number's a little lower than that.
Okay. All right, from Georgianne, if a tenant has not paid rent prior to COVID, so I guess that would be February, we'll say, and landlord has given all the resources for the tenant to apply and the tenant is not utilizing the grounds, what would the grounds be for filing an eviction and the tenant is still not making any attempts to make arrangements with the landlord? So basically we've got a tenant that owes a lot of money for a lot of months, even pre-COVID, and the landlord doesn't think that the tenant is trying hard enough to get money. What can the landlord do about that, if anything, at this point?
Right. Well, so I'm going to address it two ways. The first, I'm actually going to just take that question as an opportunity to talk about some of the exceptions to the governor's order. So because this, it sounds like a landlord is saying that something pre-COVID is making the landlord want to remove the tenant. So I just want to touch upon a very, very slim, narrow exception in the governor's protection, which is if a landlord went to court prior to COVID hitting, got an order to force the tenant out, a judgment, an eviction judgment, and then received a writ, but then was not able to execute the writ of recovery because the governor's order stopped it, those landlords can now go back, and if their writ is still good, depending on what sheriff's office you're talking to, you can now execute on that writ that was issued prior, or you can get a new writ if you've received an order prior to COVID. So I don't think that this questioner fits into that because they didn't mention that they had a judgment, but the actual question is, what do I do if my tenant's not paying? And I believe that he or she can. And, you know, I don't recommend this, but I do say that it is, from our perspective, not a violation of the governor's order to enforce your rights to receive rent. And I believe that landlords retain their traditional tools to get rent. And that is, if you want to go to court and file a small claims court action for non-payment, there's nothing in the governor's order that says you cannot do that. You can't use that as, you know, a harassment or a heavy-handed way of trying to push the tenant out. But that is a tool that you still have available to you to recover rent.
Conciliation court or small claims court, for those wondering, it costs about $70 roughly to file one of those cases. Scheduling is pretty variable around the state. It's not one state court that we're talking about. These are run by districts throughout the state. And if I had to bet, the majority of the counties aren't even scheduling conciliation court cases right now. At least if you filed one today, they're still trying to catch up on past cases. And so you might not get to court very quickly in conciliation court either for a landlord who's trying to collect rent. Question from Ashley. I think she's asking about, all right, I'll just say the question. Would this include not renewing the tenant's lease? I think she's asking about the governor's order, just judging by when she asked the question. So it's something we've been asked a couple of times, but different variations of it. Would the governor's order stop a landlord from not renewing a tenant's lease? So they have a one-year lease ending the end of September, let's say. Can the landlord give a notice saying your lease is ended? We had a one-year deal. That's all I ever agreed to with you. I'm not renewing your lease at this point.
No, nothing in the governor's order would require or give authority to the landlord to do that. Now, we're getting a lot of these questions, and I think that's just reflecting, right, the reality of the marketplace right now, which is a lot of homes turn over in the summer. And so they're all up, right, at the end of August, or especially for college students, right? I mean, last week, a lot of college students move in and out in September. So I'm happy to talk about it no matter how many times these questions come in. And again, I'm going to tells something different than what this person asked, but I would like to get this out before I get to that question. But we get a lot of tenants who come to us and say, I'm not really being forced out, but my lease is up and my landlord's given me a new lease and says I have to agree to it, right? I can only stay if I agree to the new lease, and I don't like the terms. I don't like
higher rent, right?
Something
Something like higher rent or something like that.
Higher rent, but we see a lot of things. They've changed it, so now I have to mow, and I didn't have to mow before. There's a lot of things landlords are including, and that's why I'm bringing it up in this context. Is it sure seems like the landlords are using the governor's order to try to wedge new leverage in. I don't know where they're getting that philosophy, because they're wrong. But so what we tell tenants is, don't let your need to stay in your house because there's a pandemic influence the choice you make that's long-term. So if the landlord is providing you a lease, it's a contract, right? A lease is a contract. If you are being presented with a contract whose terms you do not like, don't sign it. So what we say to people, and I think this is probably advice Homeline gives out, please tell me if I'm wrong, Mike, but you know, if you want that protection of a solid 1-year lease or 2 years, whatever it may be, and you can live with those terms, go ahead and sign it. Nothing is preventing you from doing so. But if you only need another month or two, do not feel pressured into signing a 1-year lease, and don't let the governor's order, you know, let the landlord think they can force you to sign that. And Mike, do you think I answered that question?
Yeah, no, I think you answered it right. Yeah. We haven't touched on this at all, but do you enforce, or have you heard from tenants the price gouging question, where landlords are trying to raise the rent, and there's another governor's order, there's one for everything, I think they're up to 88 now, saying the price gouging for necessities, and defining price gouging as 20% or more an increase in price. Have you seen many of those?
Yes, and so this kind of just gets at how you laughed that we may or may not have a mask expert in our office. We have several experts in our office on the price of essential consumer goods, and we've issued many press releases on this, so I'm happy to talk about it. But like at the beginning of the pandemic, there was a huge rush in price gouging on, of course, everyone knows toilet paper and hand sanitizers, so we have people in our office who are well versed in what manufacturers suggested retail prices of those products, but also rice. Rice was a high demand product, so we had people who were tracking rice prices very closely. So anyways, yes, the Executive Order 20-10 is the governor's price gouging executive order, which said essential products are not allowed to have their price jacked up over 20%. 20% is the threshold, unless you can attribute it to some, you know, some costs that went up in your stream. And the governor included housing in that essential service. And that makes sense to me. Housing is one of the most essential things during a pandemic, if not at all times, of course. So yes, if we are receiving a report that a landlord is raising rent 20% or more, and it's not attributable to something that's happened, which I can't imagine anything justifying that kind of increase, yeah, we tell them you're violating Executive Order 20-10 and you have to fix that, and we will enforce it.
The penalty's a lot bigger for that, for the price gouging, than it is for the violating the eviction order, if I remember right.
I don't think that's right, but I am not that attorney, so I won't say.
Okay, fair enough.
Yeah,
I got a new line of questioning here from Katie. What are the guidelines that someone would need to meet for a hotel to be considered their residence?
Okay, very good question. So the factors that we generally look at are how long the person has been there. If it's 2 nights, that's really going to heavily weigh against them being a tenant. They're just a hotel guest. And there is a very different statutory regulatory regime for hotel guests, and then they would fall into that. So duration is what we look at and what courts look at. Another is the rate that you're paying. If you're paying the nightly rack rate, and the rack rate is what the industry calls the rate on the website, just no negotiation, just their advertised rate. If you're paying that, you're probably a hotel guest. If your duration is short and you're paying rack rate, if you've negotiated a smaller rate, a weekly rate or a monthly rate, right, that weighs in favor of this being your residence. We also look at, is it your residence just full stop. Do you live there? And that was something that was really eye-opening for me in this work, is a lot of people live in hotels. Pre-pandemic, I spoke to someone the other day who had been there over 2 years. It was just a lifestyle that worked for him. It was a little more expensive. Actually, it was a lot more expensive than renting a home, but it was a lifestyle he liked, and he was definitely a tenant. So we look at duration, what you're paying, is it your home, are you getting mail there, factors like that. And it's a very fact-specific calculation. And so there has to be a lot of fact gathering on those files.
Yeah, I would add a couple other factors to look at. The pay stubs. Do they list that hotel as the person's address? It's a pretty, at least in the tenant's mind, they're seeing it as where they live. That's kind of their home base. This isn't true in every city, surprisingly. Most cities require an innkeeper's license, but not all do. And so having an innkeeper's license matters quite a bit in a city where they're required. I think for a landlord to make that argument, they must have that. Otherwise, it's tricky to convince somebody that they're not a tenant. Because of that really broad definition of a tenant, do you pay something in exchange to stay somewhere, which would be every hotel guest? The reason why they aren't all tenants is because there's, as you mentioned, the hotel state law and some city rules as well. Okay, from Anonymous. What if you have a tenant that was given a notice to vacate in February, to vacate at the end of April, but they didn't leave? Is there anything that can be done for that holdover?
And I assume that this is a landlord asking, is that?
I assume so too. Whenever,
Yeah.
Sometimes people identify themselves in advance like that, but this one did not. But I assume that's right.
The reason I ask is because they say, is there anything I can do?
Right.
The answer depends on if you're a tenant or a landlord. So, but I'm assuming it's a landlord. No, you cannot. A holdover, it doesn't matter why the tenant is still there. If they haven't left, they don't have to leave, in a nutshell. Again, the executive order has some narrow exceptions, and I'm just going to briefly mention them. I know we don't have time to go into all of them, and Homeline covers this thoroughly in its FAQs and on its webinars, but just for those who are new, if the tenant is a serious danger to others on the property, if the tenant has caused significant property damage, and by that I mean, removing copper plumbing. It doesn't mean they had a stain on the carpet. If the landlord wants to move into the home, they can give a proper notice to vacate with the proper amount of time to give the tenant time to leave. If the landlord has to move in, they can give a notice to a tenant. And then if the tenant holds over after that, they can evict as a holdover. But absent those very narrow exceptions, no, there is nothing a landlord can do regarding that tenant.
Got a follow-up question to what you just brought up from somebody named Law. I hope that's their first, maybe that's their first name, that could be. Anyhow, the most recent order allows a landlord to evict someone if the landlord wanted to move themselves or a family member into the unit, which you just brought up. Have you seen a lot of landlords actually doing that? And just to refresh people's mind, that came into power, or came into play August 4th, is when that new executive order took effect. Have you seen any landlords using that as a pretextual excuse to evict tenants?
So I was actually surprised when that came out. We learned about it before August 4th. Luckily, the governor issued that before it was effective, so we had time to process and digest it and evaluate it, as did the marketplace, which is great because it was pretty new for the marketplace. I thought that I would see a lot of that. Honestly, I thought it would be like, all of a sudden, everyone has a cousin who needs a home. And no, are we getting it? Absolutely. We're seeing tenants report that they received a notice to vacate because the landlord wants to move in. We're definitely seeing that. And our office has the authority and the ability to investigate. So if the tenant's informing us like, they've never mentioned this before, I don't think they have a brother, or they have many empty properties that they could be moving someone into. If the tenant is giving us information that makes it sound like it's a pretext, we definitely follow up, and we have a lot of tools in our toolbox to find out, is it a family member? We can probe those circumstances, and we do so. Courts, I hope, are also doing so. I think it really is, county by county, how good the court is doing on probing those. I have seen files where The landlord was a husband and wife, and they are breaking up, and husband moved into the rental home. If that was a pretext, that's a pretty far way to go just to get a tenant out. And so whether or not some of them were pretextual and we had to really fight hard to get the tenant protected, I can't say, because those investigatory files are confidential. We're only allowed to talk about our investigations until when they're publicly filed as a lawsuit. So I'm sorry, I can't satisfy that questioner's question on that specifically, but we're definitely getting reports of it happening, and we do follow up.
Okay. From Anonymous, are we still not able to charge late fees? So I'll add a little bit to this question.
Okay.
The CARES Act would not allow late fees to be filed. So if a landlord was or thought they were covered by the CARES Act up through July 25th, late fees were not allowed for those landlords to charge. Also, a place called Minnesota Multi-Housing Association, a landlord trade group, before the governor even issued any orders banning evictions, put out these strong recommendations for landlords throughout the state. They had no binding effect, but they said late fees shouldn't be charged. So there's been some messaging about late fees and whether they were legal or not.
Got it. And thank you for adding, because my focus is very much the governor's order. And so just to be clear, the governor's order has never had anything to do with late fees. Rent was still due and it didn't touch late fees. So that's still true under the governor's order. I can't speak to the CARES Act, and that expired July 25th.
July 25th. So that rule, we actually did see an influx of late fees starting on August 1st, where landlords just realized, well, we're not sure if we were covered by the CARES Act or not, but now we know we're not. By the way, the CDC rule, the new one, does not have a limitation on late fees. But again, we'll talk about that in depth next week. All right, got a couple questions in the chat box from Wendy. The guest gave a homeowner $40 towards cat food. I don't think that would make guest a tenant. I suppose it's a question of fact regarding what the payment was for.
A very specific question.
It is.
I'm actually going to decline to answer that one. Really just putting on my hat of the AG's office, can't give legal advice, and that's a...
I think, I mean, Wendy kind of answers it herself. I suppose it's a question of fact regarding what the payment was for.
Yeah.
Yeah, again, to be a tenant in Minnesota, you have to either owe rent or through cash or through services. It's not even really the payment. It's the fact that the tenant is expected to pay.
Right.
Yeah.
That's right. Right. So if you had a contract that said every month you will pay for my extremely expensive prescription cat food, and in exchange you can sleep in my guest room, you know, that weighs in favor of a tenant. But if it was, hey, your cat's hungry, here's $40, that kind of weighs in favor of not being a tenant.
Right. The harder ones for me are always where the tenant pays for their own groceries, but that's the only thing they pay for in the place. And they'll ask if they have the rights of a tenant or not. But again, it is a very fact-specific situation. All right, what if the tenant, from Gene, what if the tenant is not cleaning their unit and they're creating a health and safety issue for other residents? Could the landlord terminate the lease for that?
Yeah, that's not a uncommon question, actually. So the answer is, again, very fact specific, but I'll just go into some of the factors that we actually look at and that I know courts are looking at. So it really is, what is the level of harm and the level of danger? You know, did you leave some toys out in the yard? No, that's not a danger for others. But is your activities in the home to such a heightened level that someone else's health is seriously affected, then that actually might rise to the level of being an exception to the governor's protection. And it's really then going to be up to the court to look at the evidence. The tenant absolutely has a right to, let's just say an eviction was filed on that tenant and the landlord gave the 7-day eviction notice. Let's be clear, landlords, you have to give a 7-day notice before you file an eviction action in court. So if landlord does that and then goes to court and says, I'm exempted from the governor's order because this tenant is a serious danger to others because of unsanitary habits, then the tenant has the right to go to court and say that's not true. They can present their evidence. They can present their affidavits from other people in the building that say this tenant is fine, or photos. They get to present their side of the case. And then at that point, it's up to the judge.
Great. we asked you to stay till 3. We have a couple questions left. Are you okay to drift over a little bit? Eric, do you mind giving the quick recap for what's next week, and then we'll get to these last couple questions?
Yeah, thanks both Mike and Catherine. And before I do that, I also wanted to mention there was a question asked earlier when the folks from Minnesota Housing were on. Do you need to prove sustainability to qualify for the funds under the COVID-19 Housing Assistance Program? Alyssa had to leave, but she did email me and say she got the answer from Joel. No, the answer is no. Sustainability is not a requirement of that program, so you don't have to demonstrate that to apply and receive funds. So that's that. And then, yeah, just a reminder, and I put in the chat the link to more information and registration. Next week, Dan Hilton, research manager at Housing Link, is going to join us. And so he kind of does a lot of their research, and they've been doing, since the pandemic started, some evaluation of market trends and how the pandemic is impacting the market in terms of vacancies, rent levels, the ability for renters to pay, those types of things. So he's going to cover that and overall trends in the Twin Cities. And since we did just get, like you said, 16, 17 hours ago, brand new news through the CDC, we will also try to analyze that a little bit more and discuss it next week as well. Noting, of course, that as we've discussed today, from what it looks like, Minnesota's suspension is more protective. The only caveat being, of course, that it ends September 11th, could be extended, and the federal one does extend until the 31st of December. So that's next week, and we'll hit the last couple questions here.
Okay, from Georgianne, Catherine, we have, so the landlord is retaining the property is not an option. This is in response to a tenant not paying rent or utilizing rental assistance. The tenant is protected under the governor's order, correct? I think the answer is just a yes there.
The questioner said, I can't maintain the property anymore, I as landlord.
No, the landlord has the property, but the tenant isn't paying rent or utilizing rental assistance. She just wants to know, just to verify, that the tenant's still protected under the governor's order at present.
That is correct.
Yeah. Okay. Kimberly asked, and I think I have to go back in my mind a little bit to which question she asked because she's following up on one, but I think she was the one that asked about the earlier holdover that would have been given in February for the end of April. So pre all of this stuff, let's say the governor's order expires on September 11th. Could she then file for holding over on September 12th saying, hey, I gave you a notice for the end of April?
So a lot of factors would have to be answered before we could answer that, or before she could even make a plan going forward. We now have the CDC guidelines that are going to prevent eviction and tenancy terminations for non-payment. I hope it is going to apply to tenancy terminations. The language in the document is a little vague for my taste, but so that comes into play, right? So even if the governor's moratorium goes away, we're now having this federal CDC rule. And so then the question was, let's pretend there's no protections government anymore for tenants, and we're back to regular landlord-tenant law. And I think actually that's a question best for Homeline. I don't know that the governor's moratorium would change that, especially if the tenant hadn't been paying all that time. Again, it's not a rent holiday. We hear that phrase over and over. It's a rent holiday. I'm so happy I don't have to pay rent. Your rent is due and owing, and it adds up how much you're owing. So if they hold over, I don't know, Mike, I don't think I can answer that one.
To me, the key question there is whether the tenant paid rent after April. So
Right.
if they paid May's rent and the landlord accepted it, I think that notice is invalid at that point.
I see.
So it really does matter some of the key facts here, but I think once they accepted the rent past that notice time, that notice would be over. They'd have to give a new one at that point. Okay, couple last questions. Do you know how courts are interpreting the exemptions, such as the serious danger to others and significant property damage? Are there precedents being set?
That's a very timely question. I feel like I have a plant in the audience. So I don't know if you have a copy of it. I'm happy to share it with you, Homeline, but the Court of Appeals just denied a writ of mandamus on district courts not issuing summonses when an eviction is filed. And I believe the case dealt with the serious endangerment exemption. And the serious endangerment had happened many, many, many months ago. And then the landlord was using that now to evict. District court said that does not fit an exemption. We're going to classify that eviction filing as confidential, meaning filed in violation of the law, and it's not going to move forward. Tenant doesn't, you landlord don't get a hearing. The law firm filed a writ with the Court of Appeals, asking the Court of Appeals to overturn the district court, and the district court said no, that tenant did the, purported serious endangerment too long ago. They didn't use the word pretext, but it sure sounds pretextual. So district court, you're right. So that's the one piece of precedence that I'm aware of. I think that just came out yesterday. So they're starting to roll out.
Right. I mean, what you're talking about here are largely district court cases, which are notoriously not that easy to get all the information of when you're doing research. It's sort of hard for, I think, non-lawyers to believe that in our modern day, that there are court cases that are decided that are hard to access. But they actually are. Many of these cases are really hard to get that information unless you're familiar with one of the parties, and they might, after a year, they might just disappear, all the findings from the court. So even though it's a court decision that's written down, signed by a judge, it might not be easy to access, certainly online. Last question we have listed here. So is the 7-day notice, you brought this up just a couple minutes ago, and it was the first time we talked about it today. Is the 7-day notice only required at this time, or is that at all times? So I think they're asking, is this a COVID-19 rule, the 7-day thing that you just brought up?
It is. It's in the governor's order, which again is based on the peacetime emergency, which is because we have a pandemic, that he included the 7-day notice. It is not in our landlord-tenant law that has applied for 100 years. There's never, well, I'm not going to say never, sorry. In my lifetime, there has not been a 7-day notice requirement, so it is dependent on the executive order, unless the legislature puts one in.
It's a really confusing thing for tenants, especially if they do any online research, because the vast majority of states do have some sort of notice requirement before a landlord could file an eviction. Minnesota is one of a small number of states that does not. So, but right now, like you said, under COVID-19, there's this, it's actually 7 days or whatever the lease requires. So it hinges on what the lease says for a notice period under the governor's order. But that is just a COVID-19 rule. I think, Eric, you know what, you're looking at all these too. Did we get to all the questions?
We did.
I don't think Catherine even took a drink of water that whole time. Wow.
Amazing.
It is. Thank you so much for joining us, Catherine. I appreciate the insight, and I know that the people that are watching did as well.
My pleasure. Thank you.
Thanks, everybody. Thanks, Catherine. We'll maybe see you next week. Goodbye.